Unit on Business Law, meaning business law, also known as commercial law, controls the rules and regulation associated with the business. It specifies the codes related to business deals, the contact of people associated with the industry and law, related to any organization rights, order and dispute settlement. As the backbone commerce business law, every aspect of the economics marketplace, from selling up a business entry to navigated complex contractual agreement. Offer and acceptance. An offer is a statement or action that indicates a willingness to agree. Acceptance is an agreement to the terms of an offer by the other party. An offer must be communication to the person who is meant to acceptance is any may be made by the words or content. Offer and acceptance are generally recognized as essential requirements for the formation of contract and analysis of their operation is a traditional approach in contract law. The offer acceptance formula developed in 19th century. An offer and acceptance contract is an agreement hold the offer goods, service, money or promise to each other. Acceptance. As per the Indian Contract Act 1872, Section 2B, acceptance is defined as when the person to whom the proposal has been made signify his assets, that is to other is said to be acceptance dues the proposal when accepted become. Acceptance there are authority states the manager's workers acceptance of his right to give order to expert complementary expectation that our order will be carried out. Consideration. Consideration is your promise performance of forgettable begin by the promise in exchange for the promise. Consideration is the main elements of contract. Without consideration by both parties, a contract cannot be unforgettable. Consideration must be provided by promise in other order for her or him be able to enforceable promise. Promise added any only the party who has paid for promise who cannot enforceable it. There are three types of consideration in contract law: executory, past and free executory. Contractual capacity. Contractual capacity is the ability of an individuals to enter into a binding legal contract as so doing expose themselves or their company if they have signatory authority to the obligation and consequences that flow from the contract. Capacity individuals must be have capacity to understand the nature of contract in order to bound its terms. This is referenced to at contractual capacity. There are few situations which individuals may be work have contractual capacity. Concern. Business concern means any corporation, company limited, liability company, partnership, joint venture, trust, unincorporated association, or any other terms of association. A concern of controlling enterprises and one or more contractual enterprises. The relationship between the contractual enterprises it based a communication management relationship. Unlike the subsequences companies which are relatable by share ownership and voting rights outside to the proposal, the term group also mistake within the large companies of securities understood Bludge. A bound bludger is bailment of bludge property as an security for some debt or Contractual Act 1872. Contractual Act bludge has been defined the a bludge is bailment that conveyanceable possessory title to property own a debtor to the creditor to secure repayment debtor obligation and to mutual benefits of both practice. Bailment of goods as security for the payment of debt performance. Pledge of the promise is called the object of the pledge means collectively on the executed date of this instrument The shares relatable securities and relatable rights and subsequences. The financial assets identified by the consequences to which the consequences may be existing the pledge form time to complementary the financial guarantee. Some debtor or obligation to the mutual benefits of both practice